So we want to revise the paper of August 2025, the paper of August 2025. And question number 1 says, enumerate 4 limitations of a private limited company. Limitations of a private limited company. Now, if you are to look at your notes where we discussed about the companies, the classification of companies, we gave or I just read instead of sharing because we have the notes. We said that a private limited company is a company which has the following characteristics. 1, it restricts members the freedom of transfer of shares. Minimum members are 2 and maximum are 50. Prohibits invitation of the public to buy shares, not limited by guarantee, and then the certificate of incorporation states that the certificate of incorporation states that it is private. It is private. Yeah, so if those are the characters that we gave of a private company, now the examiner here is asking us what are the limitations, some of the challenges. So those ones we never captured in our notes, but they are things you can be able to tell going by those characters that we have mentioned. That number 1, there is limited public funding. Actually restricted public funding, because we have said they restrict their movement of shares. They restrict the movement of shares. So you cannot just invite the public to buy the shares. We have also mentioned the minimum number of members who are supposed to be there. And that one is also a limitation. Limited number of members. Number of members. That is a limitation to the company. When you do not have many people, then you are also very weak. Then there is what we call restrictions on share transfers. Restrictions on share transfers. Restrictions on share transfers. That is a problem with this company. And closely related to that, you could also talk of limited capital. You could talk of limited capital. So because people are not very many, they are just a minimum of 2. So we do not have a lot of capital coming from those fewer members. So they wanted 4, so those are enough. Part B, failure to maintain an accurate register of members can lead to several consequences to a company. Outline these 6 consequences. So let's look at where we discussed about the register of members. Let me search register of members. Oh, searching the wrong way. Only register of members. Register of members. If you go to that topic, the register of members. Yeah, we gave the contents of the register of members. The location, the index, the inspection. So let's scroll and see whether we get to see failure to maintain the register of members. Failure to maintain the register of members. We must have mentioned somewhere. Just try to scroll. Failure. I thought we talked of the penalties. Penalties. Penalties of non-compliance. Okay. So I don't know whether you're able to pick them. But I don't know why I'm not able to pick. One is there will be fines. I was looking for where we wrote how much fines you will be fined. I'm not able to track that in our notes quickly. Around 500,000. Fines of around of Kenya shillings 500,000 on conviction. You can even go to jail or both. The other thing is legal complications. There will be legal complications. There will be problems when you are doing these transfers. Another one is what would call reputational damage. Reputational damage. Reputational damage. Reputational damage. Your company will have image issues because you are not keeping good registers. Another one is unnecessary errors. Unnecessary errors of omission. And remember we said that if this register is not well maintained, we have legal cases. Someone can go to the court of law, someone can go to the high court, and they argue that you have not maintained the register, and the court can direct what you need to do. And then number last, which is obvious, is lack of accurate, updated data. Yeah, when you don't keep the registers, you will not have accurate and data that is updated, and therefore anything that you want to do will just be guesswork. And it will be very, very unfortunate that you're managing a company in such a way. In relation to the formation of companies in your country, discuss the differences between articles of association and memorandum of association. The differences. Now, if you look at our notes, I think that was in the topic of company formation. We discussed about the memorandum of association, and we said is a document that is used to relate or to tell the external world what the company is all about. And it is also very, very important because it contains what we call the 6 clauses. The 6 clauses. Kina name, kina liability, situation, and so on and so on. So we gave those descriptions about the 2 documents. Now the examiner here wants us to tell what are the differences. What are the differences between memorandum and the articles? The differences between memorandum and the articles. So we will get the differences from the descriptions of each, from the memorandum of association and articles of association. Memorandum and articles of association. One is that this provides powers. This provides powers and objectives. Of the company. Powers and the objectives. When we talk of the powers, that's when we were talking about the intra-vires. Intra-vires is when you do something that is within the powers. Ultra-vires is when you do something that is outside the powers of the company. The other one is it provides, number one, it provides internal operational rules. Internal operational rules or guidelines. Remember we said the articles is an internal document. It guides the internal relationships. Yeah, something else that you notice is that this one is superior to articles of association. And this one is inferior or is subject. It's subject to a memorandum. What that means is, in case there is a conflict, of what this one provides and what this one provides, we take direction from the memorandum. Memorandum is stronger. It's taken to be a superior document. The other thing is that this one cannot be altered retrospectively. This one can be altered. Can be altered. You remember we talked about alteration. This one can be altered retrospectively. What that means is that even after you have adopted that articles and people have formed a relationship based on that, it can still be changed. It can still be changed, and when it is changed, it affects what was done previously before the change. But for the memorandum, you cannot. For the memorandum, you cannot. You cannot change retrospectively. You only need to maintain, rather, once you change, you will have to go with that going forward, but not the other one. Number 4 is that it specifies the location of the company. The location of the company. Now, this one does not specify the location of the company. So it does not have what we call the situational clause. It does not have what we call the situational clause. Something else that you can be able to find when you come to compare these two is that this one is mandatory for every company. Mandatory. Now, this one is not mandatory. Although you will find that when the registrar is registering the company, they will ask for the articles. But if you do not have it, that cannot deny you registration. That cannot deny you registration. It will still be registered. Closely related to this one, we can say the scope is external looking or focused. I don't know whether that is the correct English. It's external looking. It focuses more on the external issues. And this one, the scope is internal looking. Yeah, it looks more of the internal affairs when you are dealing with the articles. The articles. Another point is that this one is difficult to alter. Difficult to alter. But on this side, it is easier to or easy to alter. It is easy to alter. It is easy to alter. So we are done with that. We now proceed to the next. So the next question is asking, question 2. In relation to shares of a company, outline 2 differences between transfer of shares and transmission of shares. So that one we covered in the topic of shares, and we said that share transfer happens, or rather, if I just remind you, is that when a company has been formed, the first persons to get the shares, they are said to have been allocated or allotted the shares. But after the persons or the members have been allotted the shares, and the shares are trading, they can exchange them. If they exchange them freely to another person, that is called a share transfer. But if they are not exchanging them freely, it is an involuntary transfer, like what we quoted. If you remember in our notes, we talked of things such as bankruptcy, being insane, that is medical issues. We also talked about things such as divorce, when the couples are separating and wanagawana the shares. All those, they speak about the transmission of shares. So the question is asking, what is the difference between, or what are some of the differences between the share transfers and the share transmission? Some differences. So transfer and transmission. So this one, you just start with what I've already explained, that this is voluntary. That's voluntary. But this other one is involuntary. It's involuntary. You are doing something that you are not willing, or at times, you are not even aware because of things such as death. And that can also be brought in as a reason. Done when selling. Done when selling or gifting shares. Yeah, that's when we talk of the transfer. Ni zako unauza ama umepea mtu ama umeitumia kama collateral. But sasa hii, it is done as a result of death. I've mentioned that. Insanity. We have also talked about bankruptcy or marital property division. Marital property division. Nagawana mali. Yeah, those are some of the reasons why we have the share transmission. So this one, the price is paid by the buyer. By the buyer. But on this other side, no price or consideration is involved. Yeah. This is where now you hear of the administrators, the trustees, the executors of the estate. So they are not making any money or not paying any money. Something closely related to this is stamp duty exists or stamp duty is paid. Now here, no stamp duty. No stamp duty, although the government will have a way of getting some taxes on the same. You don't just transfer estate. You don't just transfer estate. You'll find that they will get a way of taxing you. You get a way of taxing the person who has received them. Now, from there now, we are being asked, what are the effects of share transfer? Effects of share transfer. Effects on share transfer. Now, this one, the first one is obvious. It's obvious. One, change in ownership. Change in ownership. Yeah, and control. When I sell to you my shares, then I lose control over those shares. I lose control. Something else is change of wealth. Change of wealth of both the seller and the buyer. The seller and the buyer. Yeah. Whoever has sold, their wealth will change depending on whether they have made a profit or loss. Whoever has purchased, their wealth will also change. Yeah. Another effect, this is just very common knowledge. Another one is changing obligations in rights and obligations. To sum about the rights, the obligations of shareholders. So when you sell the shares, there will be a change. Another one is enhances continuity, enhances perpetuity, perpetuity of the company. Yeah. Remember, one of the reasons why companies are able to run in perpetuity is because there is transfer of shares. New members can buy shares, old members can sell. When a member dies or a member is not able to continue holding the shares for whatever reasons, they can transfer it or they can transmit, whichever is applicable. And as a result, the new guys who are coming in, they support the company and the company proceeds. Yeah. Another one is possibilities of restructuring. Possibilities of restructuring in the organization. Yeah, we talked about company restructuring and company reorganization. We talked of things such as mergers, such as takeovers, and so on. And we gave conditions that if a person has bought shares of this proportion, that is assured they have either formed a merger or they have done a takeover and so on. So we are likely to find those differences. Another one is there will be capital gains or losses. Capital gains or losses. Yeah, closely related to what I have said here, that the wealth will change. That the wealth of the person will change. The wealth will change. Higher. Maintenance. 5 requirements for maintenance of capital under the Companies Act. The maintenance of capital. The maintenance of capital. I don't know why my document is not giving me that option of finding. I don't want to keep on scrolling. Let me use the PDF. PDF, I think it will be easier for me to navigate so that I put the points as they are. Got where we covered about capital maintenance. Capital maintenance. I want to track there. Let me convert this to PDF. PDF is easy to find. Yeah, capital maintenance. Now I'm able to navigate well. Capital maintenance. Maintenance. Yes, can see it. Maintenance of capital. Maintenance of capital. And we gave 9 rules. Yeah, that is what I wanted. We gave 9 rules. And the examiner is asking us for how many? The examiner is asking us for 5. Number 1, dividends should already be paid if the company is solvent. Dividends should only be paid if the company is solvent. If you have money, that is the only time you pay dividends. And closely related to that, dividends must come. Dividends must come from profits only, not capital. Yeah. They must be paid from profits, not capital. Another one is that consideration must be for issued shares. Consideration must be for issued shares. For issued shares. Yeah, that's another point that we said. Another one is that shares can be issued at a premium. Shares can be issued at a premium. Shares can be issued at a premium. And another one is that a company must not purchase back its own shares. Yeah, a company must not purchase back its own shares. Yeah, those are some of the rules that are guiding. So in our notes, we have 9 points, but the examiner wanted 5. Yeah, so that has to do with maintenance of capital. Kumaanisha capital should not reduce. We should not reduce the capital. Should not reduce the capital. The next question, number 3. Identify 4 ways in which companies ensures protection of minority shareholders during company meetings. I think we covered that on protection of minority. Let me check. Minority. Yeah, protection of minority shareholders. Protection of minority shareholders. It's there in our notes, protection of minority shareholders. So number 1 is access to the information. Access to information. So the minority shareholders should be given access to the information. Yeah, they should be given access to information. Another one is right to attend meetings. Right to attend meetings. Another one is right to appoint proxies. Right, they should not be denied. the right to appoint proxies to attend. Another one is right to vote. Right to vote in a meeting. Right to vote in a meeting. And another one is right to inspect minutes book. Right to inspect minutes book. Actually, you could also even talk of the right to speak in the meeting. Yeah. So the minority shareholders must be given access to information. They must not be denied. They should be allowed to attend the meeting once they are informed it's there and the agenda and the notices have been given. If they are not able to attend in person, they can do the attendance via proxies, and we covered this, how you can appoint the proxies. We even defined who is a proxy. Once you're in the meeting, they should be allowed to vote. Yeah, their voice, and in case they want to speak, they should be there. And then after the meeting, they can have access to the minutes book. Ways in which a company can raise capital from the public. Ways in which a company can raise capital from the public. I think we looked at that. It is there in our notes. Let me see what we called it. Raising, I think we had called it raising capital. Yes, raising of share capital. Yes, we covered that. Raising of share capital. Raising of share capital. Raising of share capital. Number one, tukasema you can do IPO. Initial public offering. Initial public offering. If it's the very first time. Na kama umekuwa, you already have issued, you can do what we call seasoned equity offering. Seasoned equity offering. That's when you are issuing the shares again. Another one, you can do what we call rights issue. The company could do what we call rights issue. Rights issue. Those are the three main ways of raising share capital. But this question is talking of raising the capital from the public. So you could also issue bonds. So you issue corporate bonds, the debentures. I think we discussed debentures in one of our topics. We discussed debentures. And we also have other ways of raising funds, like crowd funding. Crowdfunding. Now, this is where you get money. It's one of the modern ways of getting money for the business. And as the name suggests, you invite many people to come and contribute. That's when you hear of Kina Euro board. Yeah. So instead of getting from one person, unachukua kidogo hapa, kidogo pale, and it becomes sufficient. So those are some of the ways in which a company can raise The examiner wanted six ways. So we have given 5. We have given 5. We could also talk of bank borrowing. Although bank is not really treated as the public, but is an outsider, you could borrow from the banks. You could borrow from the banks. That is also another way of raising money from the public. Okay. Haya, part C inasema a company director at XYZ Limited gains access to confidential financial information, revealing that the company is about to sign a lucrative contract with a major partner. Before the news became public, the director buys significant shares in the company. The deal is announced a week later, causing the share price to rise sharply. Now explain 5 strategies which could be used. 5 strategies which could be used to prevent insider trading. Strategies that can be used to prevent insider trading. Strategies that could be used to prevent insider trading. Now, if you look at our notes, let me look for that. Insider. Yes, we discussed it. Insider trading. Na tukasema it is prohibited by the Company Markets Act. Sorry, Capital Markets Act. Capital Markets Act. And we gave examples of when a person is guilty of that, and the persons who can be accused of insider trading. So the question is, how do you stop this? How do you stop this from happening? How do you stop this from happening? One is strict insider trading policy. Yeah, you have a policy that is so strict when it comes to insider trading. Yeah, so that when guys come in, they sign that we will not be doing this. Something else is having periods where shares cannot be transferred or be exchanged. Yeah, you can come up with a declaration that now that we are looking out for this contract and we are not sure whether it will succeed or not, we have put a hold on the trading of our shares until when this matter will be concluded. Yeah, so no one now takes advantage. Yeah, because by the time tunafunga, the deal is not concluded, so there has not been any impact. By the time tunafungua, the deal is concluded and everyone is in the know, so no one can take advantage over the other one. Another one is proper background checks. proper background checks before appointments. Now, this is where we just want to be sure. What is the moral level? What is the integrity level of this person that we are employing? Yeah. So you do a thorough background check. Ndio tujue huyu ni mtu ako na tabia mzuri. They will not come and misuse our information. So by the time you are hiring or appointing, you need to do that. And then there is restraint of trade policies. Restraint of trade policies. Now, this is where you restrict people on what they can do, even when they have left the company. Yeah, even when they have left the company, you cannot leave and buy the shares, because someone can realize that this information itatangazwa next week on 23rd. Na nikinunua saa hii na nikae kwa kampuni watanifuta baadaye. So I just resigned today on 15th. Then on 17th nikuje sasa ninunue hizo shares, because I know that on 23rd things will change. So hii restraint inakuzuia that even when you have left, you cannot buy, you cannot use the information you had to your advantage. The other thing is limited control or limited access. Limited access to crucial information. Yeah, we should be very careful on who gets this information. Who gets this information, because some fellows, they get it and they misuse it. Yeah, so limited access to the information. Higher. Analyze 5 circumstances when the liability of a company secretary could arise. Circumstances when the liability of a company secretary could arise. Kuna kitu tulisoma about third parties responsibilities. Let me see whether I'm able to find it quickly. Tuliita duty of care. Duty of care. Yes, duty of care. Sasa hii duty of care tulisoma kwa auditors. We looked at auditors. But for the company secretary, who is an employee and also a senior person in the organization, if you remember what we said about company secretary, the liability will come in purely for failure to do their jobs. I think that is how I can put it. And because the company secretary is more for the internal affairs, the company will hold them accountable, as opposed to an auditor whose report goes to the external world. And that's when now we start talking of the duty of care. We start talking of the breach of that duty of care. We start talking of having suffered loss. We start talking of, if I never got that information from you, I would have done something different, and so on and so on. But now for the company secretary, one is when there is professional negligence. Professional negligence. Yeah. He did not advise properly. The advice he gave or failed to give to Kipima, unasema mtu wa kariba yake, he was supposed to have given that advice properly. Another one is failure to advise. Failure to advise. So the first one is when you have advised, but in the wrong way. In a way, inaonekana this one should not have come from a trained person. But you proceed. The other one is when you have become disqualified. Disqualifications. And you continue working. If you look at your notes, you can see the list of reasons why someone can be disqualified as a company secretary. So if you become disqualified and you continue executing the duties, then you'll be held liable for the consequences. Another one is personal wrongdoing. Yeah. Personal wrongdoing. Yeah. Things that touch on you as an individual, like fraud, your language, maybe umetukana na watu, physical fighting, sexual immoralities, and so on, that are affecting the company. Yeah. Drunkenness, abuse of drugs. Those are personal reasons that will make someone to be relieved of their duties. Another one is poor corporate governance. Poor corporate. Tukipima hii governance yake tunaona is not up to date or is not meeting the expectations. And remember, a company secretary is an admin. He's supposed to ensure that there is a lot of compliances so that we don't get the fines that we are talking about here. But when we keep on finding that those things are there, then the fellow should be shown the door. Okay. We've got tumeulizwa 5 of them. So part B. ABC Limited's auditor, Mary Kiprimo, requested access to some of the company's data to complete the annual audit. Despite multiple attempts, the management denied her access, citing confidentiality concerns. Mary reminded the management that her rights are protected under the law. So explain to the management 5 rights that Mary Kiprimo has. So that one, we have it in our notes, rights of an auditor. Rights of an auditor. Let me see whether I'm able to get them quickly. Yes, powers and rights of auditors. Powers and rights of auditors. One is access at all time of company information. Yeah, the auditor has a right to access the information. Yeah, that's protected by the Companies Act. Another one is to require explanations. Yeah, the auditor can require explanations. In case he's given some data and he's not very sure or is not convinced, he can tell the management to explain further. The auditor also has right to seek professional advice. Yeah, so if maybe he's dealing with valuation of land, he can get a land valuer Maybe is assessing something that's touching on the health of some persons, so he can get a medical doctor to advise. Another one is to receive notices of meetings. Receive notices of meetings, of AGMs, of general meetings. Another one is to attend the meetings. He has a right to attend, and even when he wants to speak, he should not be told hakuna time. Yeah, should not be told hakuna time. And fair remuneration is also another right. Fair remuneration. The auditor should be entitled to a fair remuneration. Good. So I'm thinking we stop at that point. Then we shall pick up from there in our next lesson. So I hope you have seen how we are proceeding. So you'll be able to refer to your notes for more. Yeah, make sure you attempt these questions in advance. That will help us get the contents well. So if you're okay, say my yes, so that we can exit at that point. Yes, Dennis. Miriam. Yeah, so thank you very much. See you in our next lesson. That is tomorrow, to pick up from there. Good night.